Hi, Will. Hi, Leanne. Hi, Rochelle. Thanks for joining.
Good morning.
Good morning, Khairiyah. How are you this morning?
I am good, thanks, and you?
I'm very well, thanks so much for joining me this morning.
It's
I
a pleasure.
know we've been trying to line this live up for a long time now, so thanks. I'm glad it's finally here.
It's a pleasure to be here. Thank you so much for inviting me.
It's a pleasure. I know we've got a lot to discuss today, but before we begin, I'd just like to introduce us. So I'm Ariana Dwyer. Hi, everyone. Welcome. Thanks for joining us this morning. I'm Ariana Dwyer. I'm an attorney by profession, and I work for a local KZN fiduciary company called Marsh Fidelity. And we have a very special guest this morning. It's Khairiyah Safeda. She's an attorney, a conveyancer, and a notary, founder and director of Safeda and Associates, a law firm based in Johannesburg. Khairiyah, would you like to tell us a bit more about yourself and a bit about your journey? I know you've talked in previous interviews and discussions a bit about your journey and how you got to where you are today. And it wasn't always a straight line, but it led you to your passion today to help people with their life events. Would you like to tell us a bit?
Sure. Hi everyone, welcome. Thank you so much for joining us. My name is Khairiyah Safeda. As Ariana said, I own my own law firm, Safeda and Associates in Johannesburg. And I've been a conveyancer now for 10 years. And I'm originally from Cape Town. And when I moved here, I started my own practice. And in between, lots of personal things happened. But we are here today, and I've started my own practice. And we specialize in helping people make big life decisions, whether that is purchasing property and you need a conveyancer, whether that is starting a business and you need company registrations, whether that is you're getting married and you need anti-nuptial contracts. And like Ariana said today, we're going to be talking about trusts. And so we also do trust formations. And that's us in a nutshell. We are a very small boutique law firm specializing in property related services, conveyancing, notary work, trust formation, company formation, and we assist everyone here in Johannesburg. And very soon we will be able to assist everyone in South Africa. Ariana and I will be talking about that later on in the live. Things are happening in the legal space, in the conveyancing space, and we are very excited to be branching out and assisting everyone everywhere.
Thanks so much for sharing. It's so nice to work with other professionals like yourself in areas where we can work together for estate planning and for the maximum benefit of clients. Other professionals who specialize, such as yourself. At Marsh Fidelity, we specialize in estate planning, estate administration, trust management, and formations. So it's really nice to have guests like Khairiyah today to chat about areas we have in common. So I think we have a lot to chat about because you could talk about trusts for days, as we've chatted about before. But I think a common question we get is, what is a trust? I think we need to break it down today. Exactly what are we talking about when we talk about a trust? Khairiyah, would you like to jump
Yes,
in on that?
yes. So that is a common question, and I think that's a very good place to start. What is a trust? So the way that I like to explain it is it's a separate legal entity like a company where you are able to move assets into a trust, right? And there are a few key players. You will have your founder of the trust. This is the person who has decided to create the trust and transfer their assets into the trust. And then you will have your trustees. These are the people that will manage the trust and the trust assets on behalf of the founder and the beneficiaries. And then you have your beneficiaries. These are the people that will benefit from the trust and the trust assets. So it's a separate legal entity similar to a company, but we'll discuss in the ways later on. They are not exactly the same and they don't operate the same, but it is a way to keep your assets separate from your personal assets. And that is one of the major benefits, is that because it's a separate legal entity, you are able to separate your personal assets from the trust assets. And it gives you some sort of protection against creditors, because if you are in debt and the creditors come knocking on your door, they can attach your personal assets, but they cannot attach the assets in the trust.
Thanks for that. Definitely. A trust, I think, is a very unique vehicle for estate planning. It's unlike any other. There are various estate planning instruments you can use, a trust being one of them. And it's a very unique one because, like you say, it is a separate entity, but it's unique in one way, where it cannot be separated from its trustees. So the trustees are very integral to the concept of a trust. I like that you broke down the different parties. So there will be the founder, who's the person who creates the trust. And we'll talk about the ways you can create a trust just now. But the founder essentially is the person who creates it. And unless they're also a trustee or beneficiary, that's where their role ends. The founder creates the trust, and then they either move on in their capacity as a trustee and or a beneficiary, or their role is complete once the trust is set up.
Yes.
And then the trustees are actually the most important part when it comes to a trust, because they manage the trust, and depending on the type of trust, they actually own the assets of the trust, even though it is a separate entity. And then, of course, the beneficiaries are also very important, because that is the whole reason for setting up a trust, is for the benefit of the beneficiaries.
Yeah, and we need to understand that the trust is not the same as a will. A will is a legal document setting out instructions to your executor on what needs to happen to your assets when you pass on. It's not the same as a trust. I think a lot of people get confused between the two. Both a will and a trust is part of estate planning, and can assist you with your estate planning goals, but they are not the same.
100%. They are both very unique estate planning tools. A will is very important. A trust cannot replace it. I think it's important to make that clear. Estate planning starts with your will. A trust, you need to determine whether a trust suits your estate planning needs, because it can be a very useful vessel for estate planning as well, but it does not replace a will. So that's a very important point.
Yeah, and I think the confusion stems from the different types of trusts, right? Because there's something called a testamentary trust and your inter vivos trust. So those are the two common types, and there are many other different types. And Ariane and I are not going to go through all the types. We do not have enough time for that. But the testamentary trust is the trust that is created in your will, and then it will be set up after you pass on. With an inter vivos trust, it is also known as a living trust, and that is a trust that you set up while you are alive. So those are two very distinct types of trust, but it's about the difference really is, when is it set up? Is it just set up when
Yes.
you're alive, or is it set up when you pass on?
Definitely. I think that is the first way to classify a trust. The most important way is how it or when it will be set up. So either while you're alive, as you say, with a living trust, which is also known as an inter vivos trust, that one you will make an application to the Master of the High Court, and they will approve the trust while you're alive, if you're the founder. And then, like you say, with a will trust or a testamentary trust, this is set up in your will. So you have to specify all the requirements for what you want your trust to be about in your will, and then this will be set up once you pass away. I'm just going to briefly talk about some of the other ways that you can describe different types of trusts. So there's also what's known as an ownership trust. So this is about who owns the assets in the trust. So the trust is a separate entity, but ultimately a trust is created for the benefit of the beneficiaries. But the founder must also decide who do they want to own the assets ultimately in a trust. So this is either an ownership trust where the assets are owned and managed by the trustees in their capacity as trustees of the trust. And then there's what's known as a vivint trust. So this is also a unique vehicle where the beneficiaries actually own the assets in a trust, but they are managed by the trustees. So that's another way of classifying trusts. And then another important aspect that you need to decide if you want to set up a trust is, do you want it to be a discretionary or a vested trust? A discretionary trust is one where the trustees have the sole discretion about what happens, who gets distributions from the trust, which beneficiaries will benefit ultimately. So if you are a beneficiary in a discretionary trust, you have but a hope to get something from the trust. You don't get any rights to any income or assets from the trust. You are just at the discretion of the trustees whether you'll obtain benefit from the trust. So that's an important one to note as well if you want to set up a trust. What are the rights you're going to afford to beneficiaries and the trustees?
Yes, and there are so many different types, guys.
Yes.
And I think we don't have sufficient time to go through all of it, but Ariana has touched on the very common types that you will find. And it's important to note that all these trusts are regulated by the Trust Property Control Act, and they need to comply with the provisions in the Trust Property Control Act. Again, I have to say, we're not going to go through the whole entire act and discuss each and every section in the act, but all trusts must comply with the Trust Property Control Act, and they need to be registered with the Master's Office.
Yes, 100%. Definitely, you need to ensure that this is why it's good to have a professional on board who can advise you about the requirements for a valid trust and how to stay in line with legislation such as the Trust Property Control Act that you mentioned. I think we'll touch on this a bit later when we talk about the importance of staying up to date with the relevant laws and how these are changing and how they've been updated in recent years. So now you know a little bit about the types of trusts, but why would you want to set up a trust? What are the benefits of having a trust? Khairiyah, do you want to begin this one?
Yes. Yes, so we touched on this already. Because it's a separate entity, it does afford you protection against your creditors, and it keeps your assets, the assets in the trust, separate from your personal assets. So that is the major benefit. And from that, because the trust is a separate entity, it also allows you to put assets in the trust for the benefit of beneficiaries for generations to come. Because a trust is able to be around for a very long time. There isn't a cut-off date. I think a lot of people think that when the founder passes on, the trust terminates. Not necessarily, unless the trust deed has particular provisions stating, okay, this trust will be around only until the beneficiary turns 18 or until the founder passes on. But those are very specific provisions. Generally, legally, technically, the trust can be around for generations to come. And it allows one to put assets in a trust and preserve those assets for generations. We call it asset preservation. And we also call it continuity beyond the founder's death, because the trust is going to be around managing those trust assets by the trustees for a very long time for future generations. The other benefit, especially from a property perspective, is that you can have the trust owning the property, but you can still derive an income from that property, such as rental income, even though it's owned by the trust. And what's great, if you put your assets into a trust before you pass on, the assets in the trust do not get frozen in the same way that the assets in a deceased estate would get frozen during the winding up process. So it does allow for continuity of the asset preservation and asset protection beyond the lifetime of the founder. I
Definitely.
also want to mention that if you have very high income generating assets, it is advisable to put your assets in a trust from a tax perspective. And I want to put a disclaimer here. Ariana and I are not tax practitioners, but there are tax implications. And it's very important that you get advice from a tax practitioner on what is best for your assets, what is going to be the most tax efficient mechanism for those assets. Would it be better to put it in a trust or not put it in a trust, or perhaps put it in a company? But there can be tax benefits if you put assets in a trust.
Thanks for that. Definitely, those are some really important reasons to create a trust, or advantages of creating a trust. I like that you touched on the tax topic, and like you said, we are not tax practitioners. This is not tax advice. It's not telling you to set up a trust for such reasons. So historically, the appeal of trusts was for tax benefits as well as privacy for especially wealthy families. It was known as a vehicle where you could utilize those most efficiently, but there's no guarantee of that. And of course, if you have a trust, you need to ensure effective tax planning. You need to speak to a practitioner, a tax practitioner, who is experienced with trusts and can help you structure it correctly and ensure you are paying the correct taxes that you need to. Because, of course, with a trust, you can't separate it from taxes, like everything else. But it was historically known for its tax benefits. And it can be quite a tax efficient vehicle if used correctly. But of course, like Khairiyah said, you need to ensure that it fits your estate plan and that it is the correct vehicle for what you are intending to achieve. So protection of assets, that is the main benefit of a trust. Of course, it's separate from your personal estate, which means, like Khairiyah said, these assets will not be frozen on your death. They can continue to be used and they can continue to generate income even when you have passed. And so on with many family members down the line. Like Khairiyah said, there's no express date when a trust will end unless this is stipulated in the trust deed. So it can actually continue indefinitely for 100, 200, 300 years if that's what your intentions were and the managing trustees agree and the beneficiaries going forward. It can be a very nice structure to manage family assets. You can provide for income for different family members. You'll stipulate, of course, who are the income or capital beneficiaries. So basically whether the beneficiaries will receive income or just assets from the trust. It's also being used a lot today, more for things like elder care, looking after older parents, providing income for them when they can no longer provide for themselves or cannot make financial decisions. Also for minor children below 18, it's a very important tool. So a lot of people do put a trust clause in their will. So this basically means if your child is set to inherit from your will and you pass away before they turn 18, then that money, their inheritance, will go into a trust and the trustees will manage it on their behalf because, of course, they are still children. I think this is a very important point to touch on, that it's important to have this clause in your will, and we do recommend it to our clients often, just because if you do not have this clause in your will and you pass away before your child turns 18 and they're set to inherit from your will, then that money goes to the government, the Guardians Fund, to manage on your behalf for your children. So it is a good idea to have a trust clause. And then that trust, of course, will be a testamentary trust that will be set up when you pass away for your children. A trust is
Yes.
also, yes, a trust is also a nice way to provide for multiple bloodlines. So, like if you have a matriarch in a family, a grandfather or grandmother, and they want to provide for different branches of their family, they can set out how the beneficiaries' income will be managed by the trust. It's also nice for joint ownership of family assets. So, if you have a valuable heirloom in your family and you'd like to keep that safe and secure in a trust, that's also a nice way to manage it. Also, one very good advantage of a trust or purpose for a trust would be to look out for mentally or physically disabled family members who obviously can't manage their own financial affairs. To set up a trust for them can actually be a very good idea. And there are actually tax benefits as well. It's known as a special trust if it's set up for someone who is mentally or physically disabled. And in certain circumstances, also minors, young children who are descendants of the founder.
Yeah, those are some very good positives of moving assets into a trust. Of course, there are also some drawbacks with everything there would be, but I think the positives always outweigh the drawbacks. So for me, and we're not going to go into this too deeply, but I think as I go through the discussion and we explain further the benefits of trust and what you can do with trust, the major drawback is the mismanagement of trust. It's very important that you appoint trustees that are trustworthy and competent and can manage the trust efficiently. All these benefits don't mean anything if the trust isn't being administered in the correct way.
100%. That's a very important point. You need to choose your trustees very carefully because these are the people who will ultimately control and manage your trust for you to ensure that it is compliant with the law and that, of course, your intention is carried through the trust. So a fundamental principle of trust law is, of course, separation between the founder and the assets that they move into a trust. And like I said, once the trust is set up, the founder's role is now complete. So unless the founder is actually also a trustee and a beneficiary, they have no longer a part to play in the trust. So a founder can also be a trustee and a beneficiary, but especially when it comes to family trusts, it is always recommended to have an independent trustee, someone who is not related to any of the trustees or beneficiaries. This is actually becoming a requirement in recent years. It all depends on how your trust is structured. So you really need to consider whether a trust is the correct vehicle for your estate planning and whether it suits your intentions and your needs for your estate plan.
100%. And that is why it is so important that you discuss this with a legal practitioner. I wouldn't recommend setting up a trust or trying to set up a trust on your own without getting some legal advice. I think the most important thing is to get advice from a tax practitioner and a legal practitioner and work out what is best for your situation and for your family, for your circumstances, and how would you preserve your assets? What is the best method to preserve your assets and your legacy? Especially if you do have special needs children, it is very important to consider their future and their needs. And a trust is one of those methods that would be available to you to ensure that even when you pass on, your children are protected and cared for.
That's a very important point. I think it's also definitely important to consult a legal practitioner or another professional who has experience in trust management and formations. Not all legal practitioners specialize in trusts. Some of them don't work with trusts at all. So you need to look for a professional, even a fiduciary practitioner who specializes in trusts, and bonus points if they also do wills and estates, because often the two are linked. So I think it's very important to find someone who specializes in this area and a tax practitioner as well who specializes in trusts. So now you know why you would set up a trust. Of course, you need to decide whether it fits with your estate plan, but how do you go about doing this once you have decided you want to set up your trust? So as we said earlier, it can be set up in two ways, either when you pass away through a will or by agreement while you're alive. Khairiyah, would you like to touch on some of the points that you must think about before you set up a trust?
Yeah, so I do want to talk about how to set up a trust. And it's very important, like we said, to speak to a legal practitioner and a tax practitioner. But the first thing you need to think about is your trust deed. You know, what is the purpose of the trust? What are the powers of the trust? Who are going to be the trustees? How will they be appointed? Who will the beneficiaries be? How will they derive an income? Those are very important considerations when thinking about setting up a trust and whether this is the perfect vehicle for you. We also need to look at the provisions of the Trust Property Control Act. And are you capable of complying with those provisions? Are you prepared to comply with those provisions? Sometimes it can be a little bit administrative, in the same way that a company would need some company secretarial functions, and some documents need to be submitted, and all of those things. And are you prepared to do all of those things as required by the Trust Property Control Act? And think about it. And you need to actually speak to a legal practitioner and understand what is a trust, what are the provisions, what do I need to comply with, what can I put in the trust deed, what should I not put in the trust deed, what kind of powers should the trust have. Think about how many trustees you would need in your trust. Are you going to have an independent trustee? There are all sorts of factors that you need to consider and think about before you even go ahead setting up a trust.
Definitely, there's so many things to consider. And I think a very important one, especially for the founder, is, are you willing to give up control of the assets that you are going to move to a trust? Because that is the fundamental reason for a trust, is that you are now separating these from your personal estate. A lot of people like the idea of a trust, but then when it comes time to actually separate themselves from the assets and give over control to the trustees, they don't understand that you actually have to do that. So it is a big implication of a trust, is giving up control of your own assets to the trust. But it has many benefits. So like Khairiyah said, you have to determine whether that's in line with your estate plan, whether it really suits your needs and your intention for those assets. So I
Yes,
think, go ahead.
and understanding the tax implications, because of course trusts are taxed differently to individuals. So that's also something to consider. Trusts are subject to 45% tax. Also, if the purpose of the trust is to transfer immovable property to the trust will still have to pay transfer duty if it's acquiring property, and if it's selling the property, the trust would still need to pay capital gains tax. And the trust would also lose that primary residence exemption of 2 million rand. So these are all factors you need to consider in thinking about, do you set up a trust or do you not set up a trust?
I think that's a good point that you touched on. One of the myths about trusts is that they are very highly taxed, and it is true, but if structured correctly by a tax practitioner and you've planned your tax correctly, they can actually be very efficient. There are ways to structure your trust that do get the maximum benefit for your beneficiaries. I think when you go to draft your trust deed, there's a few things you need to actually consider. I think you've touched on a few of these. Namely, who would the founder be, who are the beneficiaries going to be, and what will their benefits be? Are they income or capital beneficiaries, or both? And most importantly, who your trustees will be. Are they willing to take up the appointment? What are their powers? This is a very important one. because if you don't give them powers in the trust deed, they can't act in certain ways. They are limited by the trust deed mostly.
Yeah, absolutely, absolutely. Ariana, I see we have some questions in the comments. I don't know if you want to wait until the end to answer these questions, or do you want to continue with our talking points?
I don't seem to see the questions. If there is a question, maybe if you could read it out, if you can see it on your side.
Okay, maybe I'm only seeing it on my side. So the question is, how would one go about finding a professional trustee?
So you can go onto Google and search independent trustee. There are many, many, many law firms and other service providers who provide the service. We at Marsh Fidelity do this role as well as one of our services. We act as an independent trustee on trusts, usually trusts that we set up from the beginning. So we would draft the trust deed for you in line with your intention, and then we can also come on as an independent trustee to manage your trust going forward, ensure that it meets the legal requirements. So there's many, many companies who do this service. A lot of law firms do, but like I said, not all attorneys specialize in trusts or have studied trust administration. So it is very important to find a firm or a business like Marsh Fidelity who can manage your trust for you, who's willing to be an independent trustee on your trust. There's also an organization called FISA. It's the Fiduciary Institute of Southern Africa. Most of the members are FPSAs, which is a fiduciary practitioner of Southern Africa. All of these fiduciary practitioners, FPSAs, have studied trust and estate administration and have practical experience with trusts. So you can also go onto FISA's website and have a look at all of the members there. Myself and our founder and director, Daniel Marsh, are members of FISA. So we have studied trust administration, and all the members on FISA would be able to assist you.
Thank you.
Thanks
Thank
for
you
that
for that
question.
answer, Ariana. I think let's move on to how to set up a trust. You know what a trust is, you know the benefits of the trust. We've gone through a few drawbacks also. We've spoken about what you need to consider. Let's go into how would you go about setting up this trust. So as we said, you have to consider the trustee. That is the first point that I would start off with is let's consider what needs to be in the trust deed. And we've touched on this, the beneficiaries, the trustees, how are they appointed? What is the purpose of the trust? What are the powers of the trust? And that the trust deed needs to comply with the provisions of the Trust Property Control Act, and that this trust deed needs to be registered with the master's office. And of course, we also need to open up a bank account for the trust, and the trust would need to be registered with SARS. And the most important thing that I want to mention is that the trustees need to be appointed in accordance with the trustee provisions, and letters of authority need to be issued to the trustees by the master's office.
Thanks for that. Yes, I think it's very important to understand the practical side of setting up a trust. So now you have your trust deed, it's been drafted by a professional. Now, how do you go about actually getting this trust into effect? So once your trust deed is drafted, you would lodge this original trust deed. You would deliver it to the Master of the High Court in the area where the trust assets are going to be registered. So whether that would be Johannesburg or Durban, Cape Town, every major province has master's offices in it. And then you would lodge this original trust deed, whether it is the will of a founder who has now passed away, or whether it is an agreement between the living trustees and founder. This will be lodged at the master's office, and they will then, once they have approved the trust deed that it's all in line with the law, then they will issue what is called letters of authority. This is basically a piece of paper that sets out who the trustees are, where the trust is registered, and it will give the trust a reference number at the master's office so you can locate it, and it will say the name of the trust. And then once you get these letters of authority, it means the trust is actually living and active now. Now the trustees can begin to act. it's very important to note that the trustees cannot act before they have received the letters of authority from the Master of the High Court.
Absolutely. That is the most important point, is that the trustees cannot act without these letters of authority. They do not have capacity to enter into agreements or sign any documents on behalf of a trust to be formed, or while they are still waiting for their letters of authority. Nothing can be done with this trust until the letters of authority have been issued.
I think that's a very important point, because with some other kinds of entities, like a company, for example, directors or shareholders can enter into agreements even before the company is formed, and they can be ratified later. But that's not possible with the trust. You have to have the letters of authority issued by the master before any of the trustees can act. So that's an important point to note.
So I think, Ariana, we should move on to the ways to transfer assets to a trust. We've now set up our trust. It's there. It's been accepted by the master. We've got our letters of authority. What are the ways that we would be able to move assets to a trust?
Okay, so there's several ways you can move assets into a trust, and they are all unique and come with their own technicalities, reasons that they have advantages and disadvantages. So the first one is a donation to a trust. So usually when a trust is set up, the founder makes the initial donation, which can be as little as 250 Rand, 100 Rand even, to donate to the trust. And going forward, anyone can donate to a trust. And there is a maximum of 100,000 per year that you can donate tax-free to a trust. And when you go above that, of course, it's taxed at 20%, the trust donations tax. So there are pitfalls of this method, but 100,000 per year is quite a lot. I'm sure most people agree. So you can donate a fair amount to a trust each year without tax consequences. And then there's the method of bequeathing something to a trust on your death. So when you pass away, in your will, you can say, I bequeath this asset to a trust. That's also a very nice method of leaving family assets to a trust. You can actually bequeath something to an existing trust or to a new testamentary trust, which is also nice. So you don't have to have an active and living trust if you want to bequeath something to it. And this is typically done when there's a minor or a mentally or physically disabled person involved. You can bequeath something to them, and then it will be managed on their behalf. So those are two ways. And then there's another way if the trust already has funds. So this would be a trust that has been set up already and is already generating income, or there have been donations made to the trust previously. Then the trust can acquire assets with its own funds. So if it has liquidity, cash available to do so. But in this case, you must ensure that the trustees are empowered to purchase assets, different types of assets, because if they don't have these powers, then they can't act like this unless it's in the trust deed. And then there's another option, which is a sale to a trust on loan account. So there are pitfalls of this, of course, that a loan will be created in the favor of the seller. So if a person sells a property to a trust, then the trust will owe their money, and that's an asset in their personal estate. Of course, this loan can also be paid back by donating money to the trust over time as well. And that is the goal, of course, if you do create a loan account, is to pay it back. So that this doesn't get called up when you pass away in your estate.
Yes, yes. So as Ariana mentioned, there are many ways to transfer assets to a trust. What I want to go through now and move on to now is, with immovable property, we would transfer the property from the owner to a trust. And I think that's what many of you want to do. A lot of people want to set up trusts because they are property investors and they own multiple properties and they want to move the properties to a trust for tax benefits. So how do we go about moving or transferring immovable property to a trust? Assuming that the trust is set up and everything's been approved and the master is happy and the letters of authority have been issued, we have this lovely trust already. It's it's got money in its account, it's liquid, it can it can purchase property. As a conveyancer, from a conveyancing perspective, there are a couple of things that I would call for and that I will have a look at and check to ensure that we can do this transfer to the trust. So before we even move on to the deeds office, there are a few housekeeping rules or things that I need to check before we even begin with the transfer process. So the first thing that I would call for is the trust deed. And I will review that trust deed and check that the trust has the power to actually deal with immovable property. Either it has the power to acquire the property, or it has the power to sell the property, and or it might even have the power to mortgage the property. So we need to ensure that the trust has the powers to deal with the property. Um, the next thing that I would look at also is the trustees, and I would look at the appointment of the trustees clause and what are the minimum number of trustees, and I would check, has the minimum number of trustees been appointed. Sometimes we get trusts, and as I've said before, sometimes the trusts have not been administered properly, and the minimum number of trustees have not been appointed. In that case, we need to go back and appoint the minimum number of trustees in accordance with the trust deed. And then I will also ask for the letters of authority. I will check who the trustees are. Are they still alive? And do they still have mental capacity to be a trustee? And I will also call for the identity documents of the trustees. And I have to match the identity documents to the names listed in the letters of authority. Sometimes, for some weird reason, we will have John Doe on the letters of authority, but I have an ID for John Daniels and it doesn't match. And then we need to fix that and we need to have the letters of authority amended, or perhaps someone changed their surname, etc. Anything can happen. And so as a conveyancer, I need to check all of these things. And then the next thing I would do is call for a trust meeting. And the trustees would need to agree and sign a resolution to acquire the property. Or if it's to sell the property, they need to sign a resolution to that effect to sell the property. And appoint someone to sign all the documents to give effect to that transaction. I always advise appoint one person to sign the offer to purchase. It's a lot easier than having multiple trustees sign an offer to purchase agreement. And I've seen this sometimes where trust resolutions have been drafted, but nobody checked that the trust actually can deal with property, in which case, if there's no clause stating that the trust can actually deal with property, we need to amend the trust deed. Sometimes people sign the resolutions and hasn't been signed before the offer to purchase agreement was signed. So it's very important to ensure that the resolution is taken before the signature of the offer to purchase agreement. I've seen this in some old offer to purchase agreements where people are signing on behalf of a trust to be formed. That cannot happen. A trustee cannot sign on behalf of a trust to be formed. It's different with a company. A director can sign on behalf of a company to be formed, and a resolution can be taken after the offer to purchase agreement has been signed to ratify those directors' actions. But in the case of a trust, we cannot have an offer to purchase agreement being signed by a trustee on behalf of a trust to be formed, and we cannot have a trustee signing the offer to purchase if they do not have authority to sign the offer to purchase. They need to have authority from the trust resolution and they also need to have valid letters of authority.
Definitely, 100%. Those are such important points to note. I think we touched on it earlier that a resolution by trustees cannot be ratified at a later stage. So you definitely need to ensure that it's signed and that the trustees are empowered by the trustee to enter into those transactions. Also, I liked that you verify who the trustees are because, like you say, often a trustee has passed away or has resigned and is no longer a trustee. And in that case, you would like to get the letters of authority amended, just so they are accurate and up to date, so that you don't have to have the person who is no longer a trustee sign documents as well, because that's what would be called for by the conveyancer if they see that name on the letter of authority. So it is required sometimes to update this or the trustee in certain circumstances.
Yes, and it's important to note that all these requirements need to be met before the trustee can sign the offer to purchase agreement, or in the case of selling immovable property, before the trust signs a mandate with a property practitioner. So before the trust signs any agreement, all these requirements need to be met before they sign the agreement, not after, not later, not ratified later. It must be done in advance and before. It is something that SARS and the Deeds Office call for. They will call for the trust resolution. They will call for the trustee. They will call for the letters of authority.
Definitely. I think this is why it's also important when you're drafting your trust deed or having it drafted by a professional to ensure that the sufficient powers are given to the trustee so they can enter into the different transactions that you might require for your estate plan. So someone who deals with trusts often and has practical experience would know what kind of clauses need to be in your trust deed to empower the trustees to act in certain ways with the assets.
100%. I see a lot of mistakes where the trust does not have the power to deal with the property. And I see a lot of mistakes where the trust resolutions have not been drafted correctly. And then we have to go back to the drawing board and start all over again with these requirements. I think to avoid a lot of mistakes, I would advise bringing a conveyancer on board from the beginning, right at the beginning. Often I receive signed OTP and resolutions already, and I have to do the transfer. And sometimes there are mistakes or there are errors, and it's not professional to actually tell the trustees, well, it's not professional on the part of the property practitioner or whoever was the trustee to say, look, this hasn't been drafted correctly. We have to start again and let's redo these resolutions, or let's amend the trust deed, or let's update the letters of authority, because it should have been checked from the outset. And it causes all sorts of delays when a conveyancer has not been involved from the beginning.
Definitely. And of course, with property, sometimes those are mistakes you do not want to make. And sometimes it's too late. There's nothing you can do as the conveyancer to actually fix the mistakes. So it is so important to have a professional. Same with a will as well, to get a professional to draft your will, because sometimes there are mistakes that cannot be fixed later. So it's always better to get it checked and get it done properly in the beginning.
100%. And these property transactions that do not meet these requirements are invalid. They're going to fall completely through, and each party will be able to walk away without any repercussions because there wasn't a valid agreement to begin with.
Definitely, 100%. So I think this is a good way to get into the new compliance requirements for trusts that have come up in recent years. So the compliance laws have been updated a lot. There's a lot more requirements of trusts than there used to be. So, for example, now trust practitioners must register as accountable institutions with the relevant regulatory bodies. You also need to register beneficial owners of a trust with the Master of the High Court. SARS also calls for this now. So there are updated requirements, and having an independent trustee who can advise on the recent updates and how to stay compliant with the law is so important. And I think I touched on earlier, one of the previous benefits of a trust used to be privacy. a lot of wealthy families used to use trusts because it wasn't associated, but now there's an actually you have to disclose who the beneficial owners of a trust are. That includes the founder, trustees, and beneficiaries to the master, and that becomes a public document. So there are updated requirements. And
Yes.
having a professional independent trustee really helps with clarity when it comes to trusts, understanding the requirements and managing these expectations.
Yes, and I think it's important to note that a trust is not something you set up and then you ignore it and leave it to the side. A trust requires ongoing management all the time. There needs to be trustee meetings. There needs to be financial records. You need to get the accounts audited by an auditor. You need to submit tax returns. There's a lot of ongoing management in a trust. And so we can't set up a trust and then just leave it and okay, we've done our job, we're done. That's not how a trust works. And so it's very important to have someone managing the trust that understands all these requirements.
Yes, especially when it's a family trust where you've appointed your spouse, children, grandchildren, brothers and sisters as trustees and beneficiaries. They need someone to guide them through the process of administering this trust if they are appointed as trustees, and manage the trust for them effectively to get the most returns, in line with your intention for the trust. I think this is where professionals with professional designations come in useful. It adds, they're being increasingly recognized by our courts as important as independent trustees. So if your trust is a family trust where you have all the trustees and beneficiaries related, then you need to appoint an independent trustee. The master will call for this. They actually have a duty to do so now, in the last few years. And like I mentioned before, in the answer to the question, members of FISA, for example, who are FPSAs, are a good place to start when you're looking for an independent trustee, because all of them have, some experience in trusts, and they have experience and they've studied trust law, so they can keep you updated with the requirements, and it's seen as a mark of trustworthiness. Attorneys as well, but not all of them specialize in trusts. So I think that's important to note when you're choosing an independent trustee. Choose someone who has practical experience with trusts.
100%, 100%. Ariana, I know that we have 8 minutes left. And I just wanted us to touch on the latest developments with the Master's Office. I don't know if you want to talk about how it's now digital and has gone online.
Yes, actually from this month, trusts are now fully online in all parts of the country. Before you would submit original documents to the Master's Office, you would need to get all the trustees to sign the original documents. These can now be uploaded onto the electronic trust system, which is also used for deceased estates, by the way. That's not fully online yet, but it's going that way. It's heading that way as well. But trusts are now fully online from this month, nationwide. So there's a lot less paperwork. Well, there's still a lot of paperwork, but it's all now captured online, and you can register your trust without going to the Master's Office, unless there's a will involved. Unless it's a testamentary trust, then that still needs to be lodged, the original will. But other than that, trusts are now fully online.
And it's amazing that the Master's Office has gone digital, and I'm sure it's going to make things so much easier for everyone. And I love the fact that there's this move towards digitization. I think COVID has taught us that we cannot still rely on these old methods of doing things. If we ever have another pandemic, it's going to cause a lot of chaos. I know in the Deeds Office, nothing happened for a very, very long time, and there were many backlogs. And so I'm very happy to hear about the Master's Office being online.
Yes, we are hoping it's going to be as efficient as we hope for, that it's going to really increase the speed that things move, and trust can be registered faster and can be all managed well online going forward. I think we briefly chatted about the deeds office updates the other day. I don't know if you want to touch on that as well.
Yes, yes, yes. I am super, super excited. I'm so, so happy. The D's office will also be going online soon. Me and my firm, we are part of the pilot program. And so we are being trained on the new electronic deeds registry system. And we get to play around with the system and lodge deeds and figure out what works, what's not working. We've already come across a few issues, but it's a very effective and efficient system, and it is going to reduce our turnaround times. I know a lot of people wait 5, 10 days from lodgement to hear back from the examiner. It is going to reduce those times to 3 days. So we will lodge, and 3 days later, the deed will be approved or not. It is a lovely online system where the deed itself will be put in the electronic deeds registry system. And at the moment, we are looking at either August or September for it to come live for everybody nationally. And all sale transfers, all exchange transfers, donation transfers, deceased estate transfers will be done electronically using the new EDRS system, the electronic deeds registry system, and it will be fully online. And what I really, really like about it is that it is connecting to CIPC, it is connecting to Home Affairs, it is connecting to the Legal Practitioners Council, and they are in the process of connecting it to SARS and the Master's Office. And so as we have all these public bodies going digital, it allows for all these bodies to be connected. And so when I type in an ID number, it's going to actually populate and fill out the name and the surname and which demographic they're from, for example. It's also going to allow me as an e-conveyancer to lodge deeds electronically in every single deeds office across the country. So I'm very, very, very excited, and I cannot wait to start doing e-transfers.
That's amazing. It's so nice to see the institutions working together, the Master's Office, Home Affairs, having it all linked, the deeds registry, to have it all linked will really increase efficiency. So we're hoping to see a lot of that in the years going forward, also with trusts and estates as well. So I think we've come to the end of our discussion. We've had a lot of food for thought today. Thank you so much for joining us, Khairiyah. It's been so lovely to chat to you about all the updates and how you go about setting up a trust and why you would want to trust and all of these things. So thanks so much for joining us today.
Thank you so much for having me. It was a pleasure talking to you, Ariana, and everyone else. And of course, if you have any questions, you're most welcome to contact me or Ariana. My website is www.safedalaw.coza, and you can email me at info@safedalaw.coza.
Thanks so much for that. My email address is ariana@marshfidelity.co.za. You're welcome to email me if you have any queries about trusts or estates and you'd like some assistance there. Pop some questions in the comments when we post this video. We also have a little exciting announcement just to end off this live discussion. We're going to be giving away a voucher for Take-A-Lot for the first person who can tell us what are the 2 ways that you can set up trusts. So when we post this live video, if you didn't listen to that part, you need to go back and watch. And if you pop the correct answer in the comments, you can win that voucher, the first person. We will announce that by the end of the week. So that's a Take-A-Lot voucher for the first person to say, what are the 2 ways you can set up a trust? So thanks so much for joining us again, Khairiyah. It was so lovely to chat to you. And we'll see the rest of you in the comments, or feel free to visit www.marshfidelity.co.za for more. Thank you so
Thank you,
much.
Ariana. Thank you for
Have a
having
lovely
me.
day
Have a
further.
lovely day. Cheers,
Thank
everyone.
you. Bye.
Bye.
Bye.